Today we're going to talk about trusts for children. Can a trustee and guardian be the same person? My name is Gregory Singleton. I'm an estate planning and probate attorney located in Minneapolis, Minnesota. I work for Signature Law, which serves the Twin Cities as well as Greater Minnesota alike. Just as a reminder, today's video is going to talk about Minnesota law, but a lot of the theories and principles can be applied to other jurisdictions. Just talk to an estate planning attorney in your present jurisdiction. Also, if you like today's video, please feel free to smash that like and subscribe button. It really helps support the channel. So what am I talking about when I say guardian and trustee for children? Well, take the situation of a parent, the last biological or legal parent of the child dies. In that case, they will designate someone in their will to be guardian of a minor child until they reach the age of majority of age 18. Also, at the same time, in Minnesota, a child under the age of 21 cannot inherit money, and they probably should not inherit a large amount of money either. That money and those funds must be put into a trust for the child that can be used to raise the child and will be distributed to the child at a distribution age, either 21 or some other age that's higher. So what are the options here for guardian and trustee? The first option is you can have the guardian and trustee be different people. Now, basically, in that case, you have one person raising the child and the other person overseeing the funds that will be used to raise the child. It adds a nice checks and balances on the system and makes sure that things are being done right. Some of the downsides of it, though, it's the person that's acting as a trustee sometimes doesn't have direct knowledge of what the child's needs are, and it can be seen a little frugal for what they allow to be used to raise the child. It can also create administrative difficulties because the trustee and the guardian need to have pretty close communication with each other to raise the child, turn in receipts, and all that jazz to manage both the guardianship and the trustee. The final issue you might want to look at is cost, especially if you have a corporate trustee or a trustee that is receiving compensation. If the guardian is the trustee, oftentimes they won't take compensation. But if you have a separate trustee, or definitely as a corporate trustee, they may or will expect compensation for their services. In that case, it will eat into the costs of administering the fund, administering the trust, even the principal of the trust, and there will be less money for the child. The second option is to have the guardian and trustee as the same person. Some of the benefits are the guardian and trustee, this person will know the kid best and therefore will know what needs to be used to actually raise the child properly. It's also easier on administration because instead of a guardian and trustee needing to talk with each other, it's all one person. So it's a lot easier to administer. Some of the downsides of this, of course, are intentional or unintentional corruption. Let's say that the guardian trustee decides they really need to pay for one thing that normally a trustee wouldn't allow them to pay for raising the child. You don't have anyone overseeing this or don't have any checks and balances on it, and you might get some costs associated with the trust that shouldn't be included. Also, on the flip side of that, it's much easier for a child to manipulate the guardian into paying for something if the guardian and the trustee are the same person because they're living together and they have a personal relationship. There is a third option, which I tend to like. It's to have the guardian and trustee be the same person, but you create what's called a trust protector. Now, the trust protector is a third party that oversees the actions of the trustee. They can ask for an accounting of what the trustee has done. They can remove the trustee if the trustee is not doing a good job or breaches their fiduciary duties. You kind of get the best of both worlds in that you get the trustee and guardian as the same person doing their thing, raising the child, but you still get the checks and balances of having an outside eye look over the actions of the trustee. The key to all of this, of course, is to pick the right people to be your guardian or the trustee or the trust protector. Make sure they're responsible. The trustee and the trust protector need to have some sort of mind for finance or managing money, and the guardian just needs to be a good person to raise the child. So that's essentially it. Whether you should have the trustee and guardian be the same person really depends on you. Do consider having a trust protector to oversee things. I hope you liked today's video. If you did like today's video, please feel free to smash that like and subscribe button below. It really does help support the channel. If you have any questions, please ask them in the comments below. I'll try to get to them. And if you subscribe, you will get a new video every other Wednesday. Again, I hope you enjoyed today's video, and until next time, this is Gregory Singleton with Signature Law.